The Donna Adelson trial now has officially been moved to September 17th. So we spoke about the motion to move the trial date up a few weeks. Initially, it was scheduled to coincide with the Jewish holiday of Rosh Hashanah and Yom Kippur. And as I read in the motion, Dan Rashbaum observes these holidays, and therefore he would prefer not to have to come to court and handle the trial during those dates. So he was asking the court to accommodate his religious beliefs and move the trial up a few weeks, and the court granted that motion. So now the trial for Donna Adelson was moved up to September 17th. Now this is good for two main reasons. The first very important reason is that now Brother Counsel, yours truly, will be able to cover this trial beginning to end. If it was going to be during Rosh Hashanah and Yom Kippur, during those Jewish holidays, which I also observe, I would not be able to follow the trials on those days. Of course, afterwards, I'd have to play some catch up and then give you some videos on the trial then. But it just makes everyone's lives easier so that now I'll be able to just follow the trial and without any breaks or interruptions and give you the analysis that you're looking for. So that's number one, why this is a good thing that Donna Adelson's trial was moved up to September 17th. But there's another very important reason why it's good that this trial was moved up. And that is because the sooner that we get through Donna Adelson's trial, we will be able to move on to the Harvey Adelson trial perhaps, and the queen of them all, Wendi Adelson, which everybody is just waiting for. Everybody's sitting with bated breath. When's the day going to come when the state indicts Wendi Adelson? And it's not so simple. Number one, as we know, Wendi Adelson does have an immunity agreement. And that immunity agreement provides that as long as she speaks the truth when she's testifying, the state will not be able to use any of her testimony, anything that she says, against her. And not only anything that she says, they will not be able to use against her, but anything that they learn because of what she said. I mean, if she says something to them which leads them down a different avenue of investigation and they find out other pieces of evidence, they would not be able to use that against Wendi Adelson as well. So number one is that she has the immunity agreement, and it's going to be a little tricky to make sure that all of the evidence that you're going to be using to indict Wendi Adelson, the state knew of before she gave any testimony at all. So that is number one. Or you can prove that it came from an independent source and nothing to do with her testimony. So that's going to be the first hurdle and burden on the state. But then the second hurdle is the fact that the further away you get from the actual players in this murder, the further you get away from Sigfredo Garcia, Luis Rivera, Katie Magbanoa, Charlie Adelson, Donna, so the further you get away from the main players here, the harder it is to prove that they are part of the conspiracy, right? That's just natural. The people that are at the heart of the matter, it's a little bit easier to show the conspiracy. Charlie was on the phone all day long, and he was talking to Katie. And then you also have Donna talking to Charlie all the time. And Donna, of course, said that this after the bump, she said this has to do with both of us. Right? As we know, and then she was writing all these checks from the Adelson Institute. Well, what was Wendy's involvement, if she had any involvement? And again, like I always said before, knowledge is not enough. It's not enough the fact that you knew what certain people were going to do. That does not mean that you're part of the conspiracy. So it's going to be a little bit of a harder trial to convict Wendi Adelson. Not that it can't be done, but it's a little more tricky and a few more hurdles that the state has to go through in order to convict Wendi Adelson. So I want to talk about today how I would approach this as a prosecutor. And some people have said on the channel that they appreciate all of the objective analysis that I'm doing here, which what we do here is we look at the facts, look at the evidence, present arguments for both sides of the aisle, and that's what being objective means. And some people have raised concerns that although they appreciate it very much, but they're very nervous that Dan Rashbaum and the defense team is following Brother Counsel closely and listening to the different possible arguments that I said could be made on behalf of Donna Adelson. Not that any of them are really that great anyway. I think maybe they're better than the double extortion theory, but still not that they're the most amazing arguments in the world. But still, you're giving them ideas, and they don't like that. They don't like that I'm giving ideas to the defense team for Donna Adelson. Well, today I assure you that those people will be happy, because today we're actually going to be giving tips to the prosecution. If the prosecution, Georgia Kaplan, whoever it is at that point, that is going to be indicting Wendi Adelson and having a trial, I'm going to be giving you a very important tip. And the way that this tip comes about is that some other viewers of mine suggested that I go search through some other channels that have done a deep dive on many, many different reasons, something like 100 plus reasons to indict, that they have to indict Wendi Adelson. And why? Now, first of all, in terms of indicting an individual, like I've said in my other videos, it is very, very easy to indict anyone. As the saying goes from lawyers, you can indict a ham sandwich. That's how easy it is to indict someone. Convicting someone is a different story. It's a much higher burden to convict somebody. It's much higher. You have to prove beyond a reasonable doubt in order to convict somebody, as opposed to just proving probable cause to indict someone. So let's just move on beyond the actual legalese here of whether it's indictment or whether it's actually actual conviction. So I'm going to be referring to these number of different reasons or ways to convict Wendi Adelson as ways to convict her, actually, that it has to be proven beyond a reasonable doubt. That's where I'm coming from, because indicting is very, very easy. It's a very low burden. All right. So I did go through, so someone suggested that I look through some of the videos and see all of the different reasons that are given for Wendi Adelson. And a number of them, of course, we already covered on our channel. Certainly the main popular reasons why, which point that to Wendy's involvement in the conspiracy, we've discussed in other videos. But watching these videos, and I didn't see all of it, by the way, so I didn't see all 125, whatever, how many reasons there were to indict Wendi Adelson. I didn't watch all of them, but I did watch enough to get a flavor for what was going on and seeing where different reasons are going. And I just want to talk about really today broadly about whether it's a good idea for a prosecutor to argue all these 100 and so odd points that point to Wendi Adelson's involvement in the conspiracy. And my answer to this is a very simple no. It is not a good idea. Now, some other attorneys would feel that, what do you mean? Every single piece of evidence that connects together in the puzzle, right? As Dan Rajbaum already said, each one's another piece in the puzzle. And if you have another piece of evidence which can point to Wendy's involvement in this conspiracy, why not, as a prosecutor, argue that to the jury? Why not present it? So this is the reason, okay? And this is my opinion, as trying cases, this is what I've found to be effective and what I found to be less effective. So Georgia, if you're listening, listen closely, although you probably know this already. All right. There is a common mistake, I believe, that a lot of young attorneys make and a lot of overly zealous attorneys make. And that is this exact mistake. You chase every single rabbit hole. Every single piece of information, every single fact, every single piece of evidence that could help your case or can make the witness for the other side look less credible, that you explore it and you point it out. Let me give you an example, and I'm going to show you why it's a very big mistake. Let's say you have a civil case. We're going to talk about civil case. Step away from the criminal arena for a minute. Let's say you have a civil case. You have a slip and fall. You have a plaintiff who was leaving their house, and or they're going to visit a business, whatever it was, and they slipped and fell on ice. And the ice wasn't salted, it wasn't cleared, and the business owner had a duty to make sure that his business did not have ice all over it. And this plaintiff went and slipped on the ice. Okay, now let's say you're representing the plaintiff, and the defendant is the defendant's store, and they have a witness, some guy, who is going to say that it was 70 degrees outside. It wasn't even cold enough for there to be ice in the first place. Now, let's say that witness says in his deposition, of course, he took his deposition before trial, of course, and during his deposition, he said, yeah, that morning I woke up, I fed my dog, and I went outside for a jog, and I was in my shorts. It was 75 degrees. It was great. There was no ice or snow to be seen anywhere. Now, he gets up on the stand. Now, you have the weather reports, which show that actually the weather at that time, and the time that he's claiming he went on for a jog and he was saying it was 75 degrees, you have the weather reports that show that it was actually negative 10 degrees. All right? So very great way to cross-examine him, right? But you also know that in his deposition, he said that he fed the dog. And then on the stand, he fed the dog and then went out for a jog. And then on the stand, he says that he just woke up that morning and put on his shorts and went for a jog. It doesn't say anything about the dog. So now you're thinking, oh, okay, great, I can get him on 2 points. Number one, in his deposition, he said that he fed the dog first, and then he went out for a run. And now during trial, he's saying that he didn't feed the dog. So I'm able to now destroy his credibility by showing that he lied. Did you feed the dog or not? Right? So some young attorneys or some overly zealous attorneys will attack him on that. Say, do you remember giving a deposition in this case? Oh, yes, I do. And you remember that you swore to tell the truth and the whole truth and nothing but the truth. That's right. And you remember that I told you that all of your answers are going to be written down. Yes, of course. And you remember that I said that I could be using this during trial in case you say anything different. Yeah, sure, I remember that. And do you remember that during that deposition, you said that you fed the dog that morning, and now on the stand, you said you did not feed the dog? Well, which one is true? Okay. That's one line of cross-examination that young attorneys want to explore. However, then you also have the most important part is to show that it was not 70 degrees outside. You have the weather reports. So if you just get up there and say, sir, you're telling me that it was 70 degrees that day? Yeah. These are weather reports from that day and that exact time that you were going running. Let's say it was 9 a.m. So it was 9 a.m. All right, the weather report at 9 a.m. here, which is marked as an exhibit, whatever. So this says that it was negative 10 degrees. Are you sure it was 70 degrees? It doesn't matter what he answers. You just made your point, and he's finished. He's done. Whether he fed the dog that morning, it doesn't make any difference. So don't chase every rabbit hole when you're trying a case. You got to remember the focus of what your case is and how you're going to win your case. Now, that being said, when you have a case like this, like a Wendi Adelson case, which is a little bit more of a difficult case. It's not like a Donna Adelson case. It's not like a Charlie Adelson case. You're getting further away from the main players, and it's going to be harder to prove the conspiracy. If you throw everything but the kitchen sink, which is what a lot of attorneys like to do, everything but the kitchen sink, if you throw everything at the wall and see what sticks, then you're just setting yourself up for the defense getting up there and saying, let's think. The defense can make a very clear argument. Let's think about what their evidence is. Let's talk about what the evidence they say shows clearly that Wendi Adelson was involved. And then you start talking about reason 118, that she made a phone call to her friend about lunch. I mean, come on, honestly, that's the evidence that they're using? Oh, yeah, sure, with everything tied together, then yeah, of course. You know what? When you have certain lens, when you look at things through a certain lens, everything's going to look like she's involved. No matter what she does. She could have gotten up that morning and taken a shower, and then they would have said, oh, you see, that's consciousness of guilt. And that shows you, ladies and gentlemen, what the motive of this state and prosecutor is. They could care less about what the real evidence is. They're just painting everything as though Wendi Adelson was involved. And I'm just stepping into the shoes for a second, which is why I think it's a terrible, terrible mistake. If you're going to try, if you want to convict Wendi Adelson, so listen closely. Here's all the tips for the prosecution. If you want to convict Wendi Adelson, you don't go on this 185 reasons to convict Wendi Adelson. There's a few very strong points that point to her guilt, and that's what you say. And yeah, you can throw in some other points if you want and make it clear to the jury that, yeah, this does not the best evidence, but it also shows you it also fits together with the theme as well. But if you spend, let's say, 20 minutes on your first 5 main points, and then you spend the next 40 minutes on 75 points that could be argued both ways, then it looks like that's your main argument. And that's how you lose cases. And I've done this before. I've done this where I have been losing cases and they get overly confident about their case. And they start painting every single action that my client does in a bad light. Excuse me, in a bad light. And then I'm able to get up there and say, can you listen to this? Look what they're trying to make my client look like they can't do anything right. And that's just not honest. That's not what happened here. And then you sound like the reasonable one. So, one last time. Georgia, if you're listening to this, you want to get a conviction out of Wendi Adelson, you concentrate on the main parts of the evidence, the strongest points that point to her guilt, and don't worry about all these other pieces that could be argued in 100 different ways. But yeah, technically they do also show that she's part of the the conspiracy as well. All right. So that is I'm not going to go through all 100 and whatever it is, reasons, but we kind of all know, anyone who's been following this case, what are the main strong points about Wendi Adelson's guilt. And we don't know all of them. It could be more will come out if she actually has a trial. So, you can reassess at that point. But initially, this would be my general approach, if I was a prosecutor in this case, how to get a conviction out of Wendi Adelson. All right. Well, that'll be it for today. Thank you for watching. If you haven't yet, please subscribe and like, and we will see you next time.